Hello, this is Richard Bolger. I am relatively new to doing podcasts. In fact, I'm brand new at doing them. But I hopefully am going to be providing useful information to people in an easy to understand format. And if I ever get good at this, perhaps I'll even be entertaining while I do it, which would be quite a feat to be entertaining while talking about bankruptcy law. Well, anyway. Who am I? I am an attorney. I have an office in Fairfax, Virginia, although during the pandemic, which we're in the middle of, I am on virtually anywhere now. I've been practicing bankruptcy law since 1987. I have two paralegals who have worked with me and have been with me quite some time. One's for 30 years and the other one for almost 15. So we're a good team and have done many bankruptcy cases over the years. In this podcast format, though, I thought I would like to try to put information out there which people can listen to at their convenience. And this particular podcast is intended to give you a brief description of the different types of bankruptcy. There are basically 4 types of bankruptcy, and they are referred to by the chapter of the Bankruptcy Code that they're contained in. So, for example, you have heard Chapter 7, 11, Chapter 12, Chapter 13. Those are the chapters of the Bankruptcy Code where you can find the actual statute about each of the different types of bankruptcy. Chapter 7 is called a liquidation. Chapter 11 is primarily corporate reorganizations. Chapter 12 is for farmers and fishermen, for all of you farmers and fishermen out there. And then Chapter 13 is a reorganization of individuals. I made some joke about farmers and fishermen because we don't have very many of those in the Washington metropolitan area. But this law, the federal bankruptcy law, is in just what it says there. It's a federal law, so it is nationwide. There are nuances in the way it is applied in different states, but it is a federal law, the same law in Virginia as in, Oklahoma, as in Washington state. So those are the 4 chapters of the Bankruptcy Code, Chapter 7, 11, 12, and 13. Let's go over them quickly. Chapter 7 is called a liquidation. So, in theory, assets can be liquidated in this particular chapter. Most bankruptcy cases are, however, what we call no asset Chapter 7s, whereby no property of the debtor is sold, and the debtor gets the relatively quick discharge that is available in the Chapter 7. Quick being 3 to 4 months after the case is filed, the no asset Chapter 7 debtor is going to have a discharge. Chapter 11 is primarily corporate reorganizations. I'm not going to discuss that chapter here at this time. Chapter 12 is farmers and fishermen. As I indicated, I don't do those, and I'm not going to discuss that either. So the next chapter is Chapter 13. Those are the chapters I do my work in, Chapter 7 and Chapter 13. Chapter 13 is a reorganization, and it lasts 3 to 5 years, and it involves regular monthly payments. Why, you ask, would someone do choose to file a Chapter 13 rather than a Chapter 7 if it is more expensive and if it is so much more time-consuming? Well, typically, my clients are not going to do that unless there are 1 of 2 problems. One, they have assets that I cannot protect. And I tell them before you file a Chapter 7, you have to know you would lose this asset, or you'd have to pay the trustee in charge of your case an equal amount of money to keep it, the liquidation value of the asset, whatever it may be. Or if you don't want that to happen in Chapter 7, then you can go to Chapter 13, where you don't have property liquidated unless you choose to do it, and you can keep everything you have. You just have to make regular monthly payments, And people typically go, well, how much is my monthly payment going to be? Well, that takes a bit of detailed calculating. However, in general, the proposition is you must pay in that Chapter 13 your unsecured creditors whatever they would have received had the case been liquidated in that Chapter 7. So if we look at your property and there turns out there's, say, $20,000 of property that we can't protect, then you're going to have to pay at least $20,000 over a 5-year period, 3 to 5 year period. You can typically go 5 to lower the payment, but you're going to have to pay at least that $20,000 to those unsecured creditors over that time. If you get that plan confirmed, then you don't lose any of your property. So the other type of case that might cause a person to go to Chapter 13 rather than Chapter 7 is a person who is above the median income in the area in which they file, and they cannot pass what's called the means test. The means test is something Congress introduced into the Bankruptcy Code really in 2005, which says that if you have the means to pay the money, then you can't be in the Chapter 7. You've got to go into Chapter 13. Now, merely having above median income doesn't mean you're automatically filing a Chapter 13, because the means test is what it sounds like. It's a test. There are a number of factors that go into calculating your, shall we say, disposable monthly income. You may have gross income above the median income, which causes you to go in and take the test. If you have below median income, then you don't have to take this means test. You're going to pass and qualify for Chapter 7. But if you're above median income, then there are certain allowed expenses in a person's budget which can get them below the threshold whereby they do still qualify for Chapter 7. So you could be a higher income individual with certain allowed expenses and still qualify for Chapter 7. So if you have, again, just to recap, if you have a liquidation issue or a high income issue, and you can't pass the means test, then you can go to Chapter 13 and you can reorganize. Basically, both of these Chapters 7 and 13 provide light at the end of the tunnel. It's just that one tunnel is a lot longer than the other one. So, you really want to file a Chapter 7 if you can. There are certain times where people don't even have to take the means test. There are certain exemptions from it. And maybe the most common one is if over half of the debt which the debtor has, is business debt incurred in business, then you don't have to take the means test. So that's not an issue in that particular case. That would be a business case. So people basically want to know, what chapter would be best for you. So for me, in my way of looking at things, I, as an attorney, try to see if my debtor can qualify for Chapter 7, because it's quicker, results in a much quicker rehabilitation of the person's credit, and it's a lot less expensive. So it's definitely the preferred way to go. Again, if we do the liquidation analysis, the means test is a problem, then then I can talk to you about a Chapter 13 case. Again, we're always comparing these cases to what if you do nothing. If you do nothing, do you have a better plan? And typically, for the people we file, there is not a better plan. This is the best option. And thankfully, it is a very good option, very effective when done properly. Now, what I'm telling you in that description of the different chapters is general information. And the hardest part is really, as you learn about bankruptcy on your own, is applying the law to the facts of your case. And that's really where the experience of the lawyer comes into play. And practicing law is kind of an art form, really. And years of experience just pay off, because the one thing that I think every person that files a bankruptcy case in my office wants to know is, if I file the bankruptcy case, what will I be like when it's over? What will happen to me, my property, and my debts? And you have the right to know that before you file, so that you know exactly where you're heading. There are no guarantees you're going to get, exactly to where you want to be, but there are, every reason to believe that the experience of the attorney advising you comes into play when that roadmap is drawn up. So you are going to know where you're headed, and in all likelihood, you'll get there. So that is what you need to know before you file. And in order to figure out how all of this applies to you, feel free to give me a call at my office. I don't know if I said at the beginning of this podcast, but I do have two paralegals who have been with me a long, long time. They help me with these cases. One's been with me 30 years. The other one was 15. So they're highly experienced, as well as a tight-knit team. And we take care of our clients, and would look forward to working with you.